Welcome to the Lowenstein Sandler podcast series. I'm Kevin Iredell, Chief Marketing Officer at Lowenstein Sandler. Before we begin, please take a moment to subscribe to our podcast series at lowenstein.com/podcasts or find us on Amazon Music, Apple Podcasts, Audible, iHeartRadio, Spotify, SoundCloud, or YouTube. Now let's take a listen.
Welcome to the latest episode of Just Compensation. I'm Taryn Cannataro, a counsel in the Executive Compensation and Employee Benefits Group, and I'll turn it over to my colleagues to introduce themselves.
I'm Darren Goodman, the Vice Chair of the Employee Benefits and Executive Compensation Group.
And I'm Megan Monson, a partner in the same practice group as Darren and Taryn.
And I'm Sophia Mokotoff, partner in the tax group.
Today's discussion will focus on the Internal Revenue Code Section 457A, which is a complex area of the tax code and should be considered if a U.S. person may receive deferred compensation from an overseas entity. Section 457A was enacted to target deferral of fees of certain offshore hedge funds. However, the rules are broader and could impact any non-U.S. entity. Today, we will talk about when 457 applies, to whom it applies, and some key similarities and differences between Sections 457A and 409A, which is the code provision that people normally consider in connection with deferred compensation. As always, this is not intended to be an exhaustive discussion. We encourage you to consult with legal counsel to discuss how 457A may apply to your particular situation. Let's start from the beginning. What is Section 457A and when does it apply?
457A is a provision of the tax code that, as you said, governs non-qualified deferred compensation. It applies what is called a non-qualified entity. We'll talk about that more later, but just to set the stage, 457A and 409A both regulate deferred compensation, and the rules are similar in some ways, but there are also some notable differences. For example, 457A applies to both cash and accrual method service providers, whereas 409A only applies to cash method service providers. 457A includes stock appreciation rights that are settled in cash, whereas 409A has exemptions for those as long as certain requirements are met. And these aren't mutually exclusive either. You could end up in a situation where you need to consider compliance with both 409A and 457A.
So in general, certain items are not considered non-qualified deferred compensation under either 409A or 457A. So a couple of key examples are equity interests in a partnership, stock options granted at fair market value, and payments made within the short-term deferral period. For 457A, amounts are considered to be exempt from being considered deferred compensation if the amounts are paid no later than 12 months after the end of the taxable year during which the right to receive the amount is no longer subject to a substantial risk of forfeiture. The rule is based on when the deferred amount is actually paid. And so the 457A short-term deferral definition differs from the 409A definition in a few key ways. First being the period for 457A purposes is 12 months instead of 2.5 months after the end of the calendar year. The definition of substantial risk of forfeiture is narrower, and it also applies based on whether the payments are actually made, not on whether they must be made within the applicable time frame. So as kind of Darren mentioned, there are some similarities, but some key differences to be aware of. In addition, there's also an exemption from 457A for payments made to independent contractors. The same definition is used under 457A to meet this exemption as is used under 409A. It's not enough that a person is simply an independent contractor, but they must meet the specific test, which relates to the duties that they're performing and the amount of compensation they're receiving.
Darren, Sophia, when should we be thinking of 457A?
You should think about 457A whenever there's an arrangement with a non-U.S. entity. 457A can be relevant for people in the U.S. that enter into arrangements with non-U.S. entities. For example, someone in the U.S. who's being hired by a company overseas that doesn't have a U.S. subsidiary. So the contract is directly between a company outside the U.S. and someone in the U.S. Another situation where it could apply is someone who is outside the U.S. and entering into an agreement directly with a non-U.S. entity. And Sophia can give some more color on that.
So as Darren mentioned, Section 457A can be relevant to service providers both in the U.S. and outside the U.S. Overall, the rule is it can apply to individuals who are subject to U.S. income tax. So individuals who are U.S. citizens or U.S. tax residents might be relevant regardless of where they perform services. For non-residents and non-U.S. citizens, it only applies to the extent the non-qualified deferred compensation was earned through services actually performed in the United States.
And I just want to add that this can be a real trap because companies outside the U.S. often do not have U.S. tax expertise. They might not be thinking about U.S. tax law at all. So this is something that could easily slip through 457A, 409A, or other U.S. tax principles. It's always important to be extra careful from a tax perspective if you are overseas.
Can you provide us with a high-level overview of when a plan is sponsored by a non-qualified entity?
So whether an entity is a non-qualified entity is determined on an annual basis and can change from year to year. Sophia will go into a little bit more detail about specifically what type of entities are considered non-qualified entities.
These rules about defining what is a non-qualified entity can get really complex. We're going to go through sort of a high-level overview of those rules to give you a few examples. So the analysis under all of these rules really focuses on whether substantially all of the entity's income falls within specific categories. For this purpose, substantially all is defined as at least 80%. The first category we're going to talk about are foreign corporations. For purposes of this rule, a corporation is foreign if it's formed under the laws of a non-U.S. jurisdiction. A foreign corporation defaults to a non-qualified entity unless an exception applies. One of these exceptions is substantially all of the income of the foreign corporation is effectively connected with the conduct of a U.S. trade or business. And so this is a pretty specific term for U.S. tax purposes. But generally, this means that 80% or more of its gross income is connected with a trade or business conducted in the U.S. and is actually taxable by the United States. These rules can be pretty complex and subjective in terms of whether a foreign corporation is treated as engaged in a U.S. trade or business. The analysis really focuses on the type and amount of activities being conducted by a corporation in the U.S. to generate income. So the more a corporation is in the U.S., the more likely it will be found to be engaged in a U.S. trade or business that generates ECI. Another exception is where substantially all of the income of the foreign corporation is subject to a comprehensive foreign income tax. Generally, this means that the foreign corp is eligible for the benefits under a comprehensive income tax treaty between its country of residence and the U.S. The foreign corp is not taxed under any regime or arrangement that's materially more favorable than the corporate income tax generally imposed by that non-U.S. jurisdiction. And the corporation's country of residence actually taxes non-resident source income. This gets into a lot of technical rules and considerations. Another category of potentially non-qualified entities are partnerships. And here we're not just looking at foreign partnerships. Partnerships formed under the laws of the U.S. can also be non-qualified entities. Generally speaking, if more than 20% of the partnership's gross income for a tax year is allocated to what are known as ineligible persons or entities, then the partnership is a non-qualified entity for that year. Ineligible persons or entities include non-U.S. persons who are not subject to comprehensive foreign income tax and organizations that are tax exempt under U.S. rules, including U.S. public charities, for example. As you can see, these rules get really complicated because the focus is really on the taxation of the partners of the partnership.
Megan, when is non-qualified entity status determined?
So it's determined for the taxable year of the foreign corporation in progress for the last day of each of the service provider's tax years in which compensation has been vested but remains deferred. So I'll just say all of these questions and about what is considered a non-qualified entity and how is the status determined, this is a very complex analysis and determination. And so it goes back to Darren's point of making sure that you, one, understand that this does impact entities outside of the U.S., and two, the importance of engaging with your tax or legal advisors to understand if you are going to be swept up under these rules if you're entering into any arrangement providing for deferred compensation.
And when is compensation that is subject to 457A includable in income?
So in plain English, under 457A, you can be taxed as soon as amounts are vested, even if they haven't been paid out. For 457A purposes, amounts are only not vested if there's a continued employment requirement. You have to stay employed to a particular date in order to get paid. If you have an arrangement where you do not have a continuing employment requirement, but you have another performance-based vesting element, such as company revenue or EBITDA targets, it might not be vested for all practical purposes, but you could be vested for 457A purposes. And that's a big difference from the 409A rules. If you cannot determine the amount of the compensation at the time it becomes vested, then tax is delayed until the amount actually becomes determinable. But at that time, there's a 20% penalty tax as well as interest charges. So long story short, you could be in the situation either where you're taxed on something you haven't been paid, or you're not taxed until you're paid, but you're hit with a 20% penalty plus interest. So both are bad outcomes tax-wise.
Is there anything else that we should be aware of with respect to 457A?
As we mentioned, 457A and whether or not it applies is a really complicated area of the law. And since many non-U.S. companies are often not aware of it, the key takeaway is if a non-U.S. company is hiring a U.S. person to consider, one, does 457A apply to any of the arrangement, and to bring in local counsel to help advise on it. As a related point, it can also be relevant to somebody in the U.S. if you're being hired by an overseas company. And so again, it really just strikes the importance of having U.S. counsel evaluate any sort of compensation arrangements to determine whether 457A is something that needs to be complied with, in addition to other U.S. law.
As you've heard today, it's important to keep 457A in mind when dealing with non-qualified deferred compensation arrangements from non-U.S. entities. As you can see, the rules of 457A, just like 409A, can be very tricky and technical. While the rules of 457A and 409A are similar, there are also key differences to be mindful of, especially if there's an arrangement that could be subject to both. U.S. legal counsel should be considered if you're looking to put in place any arrangement that could be subject to 457A or 409A in order to avoid adverse tax consequences. This episode is intended to be a high-level overview, but is by no means an exhaustive discussion. Thank you for joining today. We look forward to having you back for our next episode of Just Compensation.
Thank you for listening to today's episode. Please subscribe to our podcast series at lowenstein.com/podcasts or find us on Amazon Music, Apple Podcasts, Audible, iHeartRadio, Spotify, SoundCloud, or YouTube. Lowenstein Sandler podcast series is presented by Lowenstein Sandler and cannot be copied or rebroadcast without consent. The information provided is intended for a general audience and is not legal advice or a substitute for the advice of counsel. Prior results do not guarantee a similar outcome. Content reflects the personal views and opinions of the participants. No attorney-client relationship is being created by this podcast, and all rights are reserved.